for joining us today for our sanctions webinar. I just wanted to go over a few housekeeping items before I hand it over to our panel. For those of you who don't know me, I am Hannah Shea, World Law Group's Manager of Communications and Network Development. You have been muted upon arrival, and I ask that you please stay muted until we do Q&A at the end. If you have questions, you can either drop them in the chat at any point, or at the end when we do the Q&A, you can use the raise hand feature if you want to actually ask your question. This is being recorded, just FYI. I think you had to click a button when you signed in to accept that you're being recorded. We will post this to our website after so that you have access to share this with colleagues and clients. With that, I'm going to go ahead and hand it over to Vera Canas, who is the co-chair of our international trade group. Vera?
Thank you, Hannah. Good morning, good afternoon, good evening for you. On behalf of the International Trade Committee of the World Law Group, I'd like to thank you for attending our webinar, Sanctions, the Evolving World We're In. This is not our first event about sanctions, and due to the increasing importance of this tool in the challenging international scenario we are in, this will not be the last either. Sanctions intend to force the rival to change its behavior. So they usually target the sensitive aspects of the economy of the opponent in a harsh and fast manner. And sanctions are eventually based on economic power. In this context, they seem unfair if we consider the principle that the trade should be based on rules and on transparency should prevail. But certainly they are a peaceful alternative to military war to solve certain conflicts. The sanctions against Russia are the broadest ever imposed against a country. Covering all the sanctions will take us several hours of presentation. In this webinar, we will provide you with an overview of the sanctions imposed by the US, the European Union, and by Australia and New Zealand. My name is Vera Canas, partner in charge of the International Trade Practice Group at Tosini Freire, Brazil. And I will moderate this webinar from the perspective of a country that does not impose unilateral sanctions, but that is eventually impacted by them. Molly Sitkovsky, partner at Fager Drinker Chicago, will speak about the US trade sanctions, laws and regulations. Molly assists with export controls and compliance matters, including advising on export screening and classification, and filing license classification requests and voluntary disclosures with the U.S. Department of Commerce Bureau of Industry and Security and the U.S. Department of State's Directorate of Defense Trade Controls. She advises U.S. headquartered multinationals, as well as foreign-based multinationals, on compliance with the U.S. sanctions laws and the extraterritorial reach of the U.S. export controls. Michael Brueggemann will be in charge of the trade sanctions in the European Union. Michael is partner at Taylor West in Germany. He is member of the competition, EU, and trade practice area and focused on all aspects of European public procurement, state aid, and foreign trade law. Michael advises companies on the EU legal framework for imports, trade remedies, EU free trade agreements, and the EU anti-dumping regime. He also focused on advising exporting companies in terms of embargoes and trade restrictions from the EU dual-use regulation. He carries out trade compliance reviews and training on a regular basis. David Murphy will focus on the sanctions imposed by Australia and New Zealand. As a director of Minter Ellison International Trade Group in Australia, David specialized in WTO law, free trade agreements, bilateral investment treaties, anti-bribery and corruption, sanctions, export controls, trade remedies, customs matters, and regulatory matters affecting trade in goods and services. Prior to joining Minter Ellison, David was a trade negotiator for the Office of the United States Trade Representative in the Executive Office of the President, based in both Washington, D.C. and Geneva. In addition to the U.S. Free Trade Agreement negotiations and service as delegate to the WTO and UN organizations in Geneva, he represented the U.S. as counsel and technical expert for the WTO dispute resolution. What a team, huh? But now let's start from the basic question. Hannah, you can what exactly is a sanction? Well, international sanctions are actions taken by countries against other countries for political reasons and they can be unilateral or multilateral. The multilateral ones are usually adopted by the United Nations. And today we are going to talk about the unilateral ones. Most countries do not adopt unilateral sanctions, like Brazil, for example, but today we are going to talk about the main stakeholders in the unilateral sanctions. The sanctions can be diplomatic, from sports, military, like intervening in another country, and economic. We are going to talk about economic ones today. Economic sanctions are actions or restrictions related to the economy, several aspects of the economy and trade in general. They can include trade bans, embargoes, and financial restrictions as well. They can cover a whole country or just a region. They can target a company or an entity. They also target individuals, and they can target certain products or sectors. Now, going to the subject today, what are the current sanctions and to whom do they apply? I'd like to ask each of our panelists to talk about the current sanctions issued in their regions. Molly, you can start with the US, please. The floor is yours.
Vera, I thought it was nice how you say Brazil doesn't do unilateral sanctions. Well, that's kind of all the US does. So, so our sanctions on Russia with respect to its actions in the Ukraine or the Ukrainian territory have actually been in place for 8 years now. So beginning in 2014, there were a series of executive orders. So our president can take unilateral action, not just with, not including other countries, but also not including our Congress. Our president can issue executive orders implementing sanctions. And so our sanctions on Russia began with Executive Order 13662 and a series of executive orders in 2014. And these essentially made Crimea into an embargoed region. So kind of like our sanctions on Iran and Cuba, we did the same thing with Crimea. It also allowed the Department of Treasury Office of Foreign Assets Control to block individuals and entities that it had determined were benefiting from or participating in any hostilities by Russia in Crimea. So that was kind of the beginning, and that is actually what the current sanctions are largely based on. They're very similar to the sanctions that started in 2014. So the next step in the US sanctions against Russia were the passage by Congress. So this was an interesting development in the sanctions world where Congress directed the President Trump at the time, to issue sanctions on certain Russian individuals. And this was in the Countering America's Adversaries Through Sanctions Act, which passed in 2017 and took effect in 2018. Notably, this act allows the Department of Treasury to implement secondary sanctions against entities or individuals that aren't technically subject to US jurisdiction, who are engaging in certain significant transactions with Russia or other sanctions target involving the Russian conflict. It also authorized something called non-specially designated national menu-based sanctions, non-SDN menu-based sanctions. And those two things are interesting because our current sanctions have not yet impacted secondary sanctions, although that may be on the table depending on what China does. But a lot of the sanctions that are in place today that began last month are these non-SDN menu-based sanctions. So last April 2021, President Biden issued Executive Order 14024. And this is what the current sanctions that have been implemented over the past month are based on. So this allowed blocking of assets of individuals and entities who are determined to contribute to undermining security in foreign countries outside Russia. So almost all of our blocked individuals and sanctions have been based on this EO 14024 over the past month. That's kind of the legislative and regulatory background. And so to summarize, basically everything that happened in the past 8 years has led up to a US sanctions regime where many individuals and entities, including oligarchs, have been blocked on either the SDN list or on the non-SDN menu-based sanctions. And the non-SDN menu-based sanctions are a series of directives which have different prohibitions. We're also seeing a lot of non-SDN menu-based sanctions being implemented against banks and their subsidiaries. So many banks are subject to different directives which prohibit US persons or US financial institutions from certain transactions with them. We've also seen 5 banks get added to our SDN list, which means that all transactions with a US nexus, which Vera will talk about, are prohibited with those banks. We have now seen Donetsk and Luhansk be added to the general embargo that is on Crimea. So all US transactions with the US nexus are prohibited with those regions. And now we're going to start to see oil and gas sanctions and export controls. And export controls brings us to the next slide very quickly. US sanctions and US export controls are tied intimately together, especially when it comes to countries that are not subject to full embargoes. So in addition to the sanctions that have been put in place over the past month, we've also seen the Department of Commerce Bureau of Industry and Security, BIS. We have seen that entity implement a series of new export controls on exports to Russia. This includes what would typically be called dual use items. So items that are described on our commerce control list or our Wassenaar arrangement dual use list. It also includes non-dual use items. So last week, BIS implemented restrictions on the export of luxury items to Russia or to oligarchs outside Russia. And most of those luxury items are non-dual use or EAR 99 in the United States. We've also seen BIS increase its export controls on items that can be used in the oil and gas industry in Russia. And this was 2 or 3 weeks ago. The oil and gas dual use or non-dual use restrictions have been in place since 2014, but BIS has expanded this to a list of much greater and wider arrangements. And these are based on the tariff schedule, harmonized tariff schedule classification of the items rather than their dual use classification. The major changes, though, that BIS put in place on dual use items specifically is that all category 3 through 9 items that have been manufactured or transshipped through the United States require a license when destined for Russia or Belarus now. And then also, if a company knows that a military end user is involved or has reason to believe a military end user involved, all items subject to the Export Administration Regulations, EAR, require a license, even if they are non-dual use or EAR 99. So that has been the biggest restriction that has occurred for Russia and Belarus over the past month. BIS also expanded the definition of what can be considered an item subject to our export regulations with an expansion of something known as the Foreign Direct Product Rule. And basically the Foreign Direct Product Rule says that certain things manufactured outside the United States can still be considered subject to our export controls if they're based on certain US technology or in plants containing certain US equipment. So that has been the biggest expansion and one that is giving clients globally headaches, because now even if something's manufactured outside the United States, it might still be subject to our rules. Thank you, Vera.
I think you're muted. Okay.
Yeah, I'm sorry. How about in the EU, Michael?
Yeah, thank you, Molly and Vera. The EU concept is quite similar to the US one, even though the personal scope of the sanctions and the scope of the sanctions at all is narrower, as we have now secondary sanctions. And as with the US, the EU sanctions against Russia based on the sanctions that have been implemented in 2014 with the occupation of Crimea by Russia. And since 2014, we had 2 sanctions regulations in place, which are directly applicable in every EU member state, and which basically provided for export bans related to the Russian oil industry, which also contained some financial sanctions regarding Russian banks in the financial sector, and which also included a far-reaching export and import ban regarding the Crimea area, and also a prohibition and authorization requirement for dual-use items as far as they had an military end use. And based on these two regulations, the EU implemented new sanctions since February 24th, when Russia invaded Ukraine. And we had at all since then 4 sanction packages. And first, the dual-use regime was strengthened. As I mentioned beforehand, there was a limitation for military end-use dual-use items, and now that was extended to every dual-use item. So the export of dual-use items is now generally prohibited, irrespective of the end use in Russia. There is a provision, a so-called old contract provision, that you can apply for an authorization if the contract was concluded before February 26th. And then you can apply for an authorization until May of 2022, in case you have no military end use, and in case you can prove that there is no military end use, basically. So that is one of the most practically relevant measures that we have. We also have an export ban now based on a so-called high-tech list, which includes certain high-tech items like chips and aviation related products, and which clearly aims on targeting Russian high-tech industry and preventing Russian industry to make use of these advanced technologies, and in particular also aiming on a military use. In addition to that, the export ban and the import ban, which was so far related to Crimea, was extended to the Luhansk and Donetsk region, the separatist republics. And there are also new financial sanctions regarding the Russian National Bank, but also regarding certain banks which are now excluded from the SWIFT system, even though there are exemptions, like for Gazprom Bank, which is, as you know, much criticized because this bank is required for the oil and gas exports, and therefore it was for the time being excluded from the measures. And in addition, like the US, we have person-related measures, listings, which includes high-ranking Russian politicals like President Putin and the Foreign Secretary Lavrov, but also all members of the Duma parliament, and in addition, certain oligarchs. And when it comes to those designated person, you have a so-called provision ban. So it's prohibited to make available any money and other funds and means which can be transferred into money to those persons. And there's also an indirect provision ban related to persons and entities controlled by those designated persons. So that's in a nutshell the overview on the EU sanctions regime, which was implemented now in the course of the Russian invasion of Ukraine.
And David, what do they look like in Australia and in New Zealand?
We're getting there. There they are. Oh, they're still blue. Here we are. G'day. This first slide, I won't go through them all, but talking about Australia and New Zealand, two separate sanctions regimes, I thought it a good idea to put this up to give you an idea that Australia's been at this a little bit longer than New Zealand has in terms of autonomous sanctions. In fact, New Zealand got into the sanctions game a little bit after Switzerland did. And so it's a very big step for them to do. But like the US, sanctions on Russia, if you take a look down the list, designated persons and entities goes back to 2014 and was updated in 2015 for the Crimea and Sevastopol regions and that action. This has been going on for quite a while. If you could. Next slide, please. Now, a lot of information. I won't go through all of that and bore you with it, but restrictions on the export or supply of certain goods. And I highlight aluminium there, or as we used to say in the US, aluminum. But aluminium is an important one here in Australia, and we'll talk a bit more about that later. So import and export both banned. If you go down, one thing that people have asked me is why we haven't announced that we're seizing any oligarchs' ships or planes or anything like that, like other countries have. And I said, well, it's not necessarily that they're seizing their planes by action, by regulatory action. What they're doing is restricting dealing with assets of designated persons. And so you don't see navies sailing up to super yachts and seizing them. But I live in Australia, it's very far away. When a super yacht gets here, it needs to fill up with petrol. And as soon as they do, you are aiding someone to utilize an asset. And you can't do that. That's when you seize the asset. That's when the asset is frozen. This has been in the rules here for a long time. But that's how that works. The specific sanctions have been, there was a list until this past Friday, it had 41 oligarchs. They added 2 more to it, so now it's 43. And they added 11 more Russian banks. So altogether, 80 to 85% of all Russian financial transactions are covered under Australia's, the institutions that do those transactions are covered under Australian sanctions. New Zealand is still catching up a bit, but they're serious. And this week have actually started to put flesh on the bone. It was about 2 weeks ago that they passed the law that allowed them to do it. The act, the Russian Sanctions Act. This week, they implemented those sanctions, and they prohibited the dealings in assets or services of 18 military entities, 1 Russian state bank, and the Russian president, prime minister, foreign minister, and the like. I expect the US, Molly will tell you how often the updates are coming out and the new sanctions are coming out. The EU's pretty consistent. Australia's absolutely rapid fire. I expect more out of New Zealand as well. And I expect them to follow suit in a way that's targeted.
Yeah, thank you, David. But still to you, how customized are they, those sanctions? Are sanctions applied differently across jurisdictions?
Well, I did mention a couple of things there. And the last thing I said is they're targeted. And it's very likely to be targeted. Aluminium I mentioned a couple of times, just because I like pronouncing the word aluminium as Australians do, but also because I also mentioned 2 oligarchs were added to the list. One of them is invested in the largest aluminium smelter in Australia. And the other one is invested in natural gas, also prohibited exports and imports, get oil and gas. That those are targeted. Those 2 oligarchs weren't picked just because they're oligarchs. They're picked because those particular sanctions will have impact, and our economy can have that impact. When you look at New Zealand, it's not exactly the largest economy going, but it's an economy and it's a vibrant one. And if anybody is invested there or doing business there that can be targeted, that's how you figure out who's going to be targeted where. Do they have investments there? If they do, look out. And the reason to look out is because here, one of our biggest mining companies is the partner of that Russian entity that has the aluminum smelter. One of our biggest energy companies is the partner that is involved in the gas venture. They have a problem now. They didn't have one, didn't know it when they got into the venture. They have one now and they have to extricate themselves from that situation. So when you target something like this, yes, you're doing, you're having the impact in Russia that you're looking for, but it also has impact at home. And that's how these things need to be balanced and understood. And they have fairly immediate impact. There can be some transition time, there will be some transition time, but not a lot to unwind some very big deals.
Thank you, David. Now, the next question is for all of you. What could happen if I am, or if my client is found in violation of the sanctions, and what are the penalties?
I mean, I can start because we have a fairly robust penalty regime. Actually, Hannah, do you mind going back to the U.S. nexus? So the first question in, any sanctions analysis is going to be, okay, this is prohibited under U.S. law, but is there a U.S. nexus? And so that's the first question I would ask, because otherwise then you're looking at secondary sanctions, which there might be penalties for. But the civil penalties and the criminal penalties come when there's a U.S. nexus. And so a U.S. nexus arises from the involvement of a U.S. person. So this is citizens of the U.S. wherever located. So David, I think you're still a citizen of the U.S., right? So if you want to, open up a Cuban cigar shop in Australia, technically as a U.S. person, you're still prohibited from doing that. Sorry to ruin your retirement plans. It also includes companies organized under the laws of the U.S. wherever they're acting. So a U.S. company, might have, let's say they have sales reps or whatever in Russia. If they're the contracting company, they're still the company doing business with Russia. For purposes of Iran and Cuban sanctions only currently, and who knows, this could be expanded to Russia, a U.S. person includes foreign subsidiaries of U.S. companies. That is not yet the case with Russian sanctions, but that is something that the U.S. could do to expand the sanctions reach. U.S. goods also are enough to create a nexus, and I briefly talked about how the BIS is expanding the definition of a U.S., an item subject to the EAR with its expanded foreign direct product rule with respect to Russia. So items subject to the EAR include anything manufactured or transshipped through the United States. It includes software or technology that's developed in the United States. And then it includes commodities manufactured outside the United States if they contain more than a certain level of U.S. content, controlled content, or if they're subject to this foreign direct product rule. U.S. banks, anytime a U.S. bank is involved in a transaction, they're going to comply with U.S. sanctions, whether or not the rest of the transaction has another US nexus to it. And then OFAC has also stated in, a couple settlement agreements that just the mere involvement of the US dollar is enough to give OFAC a jurisdictional reach over a transaction. So, whenever I'm talking about penalties, that's the first question I ask. Okay, this is prohibited, but does it have a US nexus? So our penalty regime there's a lot of settlement agreements, there's a lot of cases, there's a lot of precedent for the US, civil penalties for violations of OFAC or BIS regulations. And these are more than $330,000 or twice the amount of the value of the underlying transaction, whichever's higher. And these are, $330,000 per violation. So you can have one transaction that could have 5 or 6 violations in it. So they can stack that $330,000 number. There's also criminal penalties. So if something was willful or there was knowledge that it was violating sanctions, but a company went and did it anyway, those penalties are more than $1 million criminal penalties. And for individuals, it could be more than 20 years in jail. So David, you definitely don't want to do that Cuban cigar shop. Then there are other administrative penalties. So this includes denial of export privileges, listing on one of our many different bad guy lists, or debarment from government contracting. So, if it's against US, if it's prohibited by US sanctions and there's a US nexus, these are what you're looking at. Who's next? Michael, you want to go next?
Yeah, yeah, sure. Thank you, Molly. I mean, the EU sanctions, as I mentioned in the beginning, from the personal scope, they are a little bit more tightened and narrower than the US approach, because they basically only apply to EU citizens and EU-based entities. And I mean, that's a big difference between your sanctions and ours. And that's also the reason why most of our clients also ask for the scope of US sanctions, because every EU company who has business in the US, of course, needs to consider then US sanctions because of this nexus, and also because of possible secondary sanctions. But when it comes to the EU sanctions itself, as I mentioned, they are basically concerning EU citizens and EU-based companies. Yeah, and I mean, from the scope of the sanctions itself, we have some differences between the US approach and ours, because as I mentioned in the beginning, we have this so-called provision ban, which prohibits a EU company or an EU citizen to do business with a designated person. But contrary to your system, it also includes an indirect provision ban. And therefore, you need to figure out whether your business partner is controlled by a designated person. I think we'll discuss it in more detail later on in the webinar. When it comes to the consequences, the legal consequences of a sanction breach, we have administrative penalties, fines of up to 10 million, but also prison sentence. And there have been some judgment in recent years, mainly relating to Iran sanctions. And there have been, in fact, some prison sentences when it came to the export of sensitive technology required for the Iran nuclear program, but also related to arms technology, which was exported to Iran in breach of the sanctions. And the legal consequences of a breach of the Russia sanctions are quite similar. And in the EU, this, as I mentioned, the sanctions regime itself, it's governed on the EU level. We have these 2 EU regulations, which form the legal basis of all the Russia sanctions. it has been now amended and supplemented in the course of these 4 packages, but it's mainly based on the 2 regulations. But the legal consequences of a breach of the sanctions and the administration of the sanctions is left to the member states. And therefore, there are some differences. For instance, when it comes to the asset freeze, regarding to the designated persons, we have this provision ban, but also an asset freeze. And therefore, in principle, the assets of the designated persons, of the oligarchs, and also the members of the parliament, some of them have assets and real estate in the EU, and there are differences in the execution. I think Italy is the front runner in this regard. They have already seized some ships and also real estate, while Germany is quite reluctant, and there are in particular problems in figuring out the exact control over certain assets like ships. There are some ships in the Hamburg harbor which are refurbished there, and where there's public discussion going on whether they are related to an oligarch or not. And yeah, also regarding real estate, and that's also a consequence of this so-called indirect provision ban, which I will explain later on.
If you could go to the US jurisdiction slide, that would be great. Yep, there. No, not US, sorry. I'm thinking of old home, new home, Australia, New Zealand, please. New, I've been here for 13 years. You'd think I'd get it right. It's a bit late at night here, folks. Jurisdiction is the one I was looking for Australia, New Zealand. That's the one. And it's somewhat straightforward. I wanted to come back to this because New Zealand is interesting. And again, they're new at the autonomous sanctions game, but they've got a very strong extraterritorial reach if you know how to read what it is they drafted. First of all New Zealand persons. And this is defined to include an entity carrying on business in New Zealand. Sounds straightforward, but somebody mentioned before that foreign subsidiaries were not yet covered, but they very well could be. In New Zealand, under their Companies Act, carrying on business in New Zealand includes the parent company of subsidiaries. So that's an extraterritorial effect in a big way. So it's important to understand who a New Zealand person is under New Zealand law to know that this has a broad reach. Otherwise, it is similar to Australia, where it applies to activities that go on in Australia, activities by Australian citizens or registered bodies of corporate, either in Australia or overseas. Or I love the one that's on board Australian flag vessels or aircraft. So if you're halfway over the Pacific on an airplane, on a Qantas jet, and you violate sanctions, you're subject to Australian law. And if we go to penalties now, there it is. They are substantial. In Australia, up to 10 years in prison for individuals, and fine up to 555,000 for individuals, up to 2.22 million for bodies corporate. It's good to understand also that for bodies corporate, this is a strict liability offense. It's not necessary to prove any fault element in doing this. Intent, knowledge, recklessness, negligence, not necessary for a body corporate. It's strict liability. If you did it, you did it. Case closed. But there's also giving false and misleading information. So if you gave false information in order to obtain a sanctions permit, I'm not sending it to that guy, I'm sending it to these nice people. And that's not true. That's another 555,000 as a possibility. And that sanctions permit would be treated as if it were never actually issued. In New Zealand, for body corporate, it's $1 million. For individuals, up to 5 years in prison, a fine that would not exceed 100,000 or both. But there's also reporting obligations in the Act that would carry a $200,000 fine, or for individuals up to 1 year in prison and a fine of $20,000. So New Zealand's well and truly into it. If you take the jurisdictional aspect and the penalty aspect, they're really the mouse that roared. It's they're taking this seriously.
And David, I'll echo, in the US, it's also strict liability. So, you know, the amount of due diligence that you've done doesn't officially matter, but it will be taken into account in mitigating any penalties. But OFAC, BIS, they don't have to prove that you were negligent at all.
Thank you. Now, the next question for you is, what would you say are some best practices for businesses, and how do they know if they can sell to entities? Please, Michael, for you first.
Yeah, I mean, in Germany and the EU, companies are not basically required to have an export control compliance system. It's better to have one because it provides you some easement when it comes to export authorizations. And of course, if you are doing business related to sanctioned countries, it's recommended to have a compliance system because in order to avoid risk in that regard. And so, I mean, the basic instrument is a screening program, which of course most companies have that are doing business related to sanctioned countries. I mean, you can do it based on the freely available lists. There is the EU consolidated list of sanctions, which is freely available on the Commission website. And there's also of course, the OFAC list, which is also freely available. But when it comes to the EU, we have this particularity that we have this indirect provision ban, meaning that the provision ban regarding designated persons does not only concern the designated person itself, but also persons that are directly or indirectly controlled by that sanctioned person. And the provision ban, it means that you are prohibited to directly or indirectly make funds or economic resources available to those designated persons. And I mean, the difficulty here is to figure out whether an entity is controlled by a designated person, because in recent days we have some oligarchs who sold their shares in certain German companies to their wife or to foundations in order to circumvent this provision ban. And basically the term control, as we know it from corporate law or antitrust law, it refers to a 50% shareholding in the target company. But you can also have control via a dominant influence. And the EU Commission has issued some guidance in that regard, some criteria which can form such an dominant influence. And inter alia, it's relevant whether you have the right or exercise the power to appoint a majority of the members of the management, or if you have certain control rights and voting rights, which go beyond your shareholding, and other forms to power the exercise, to have a dominant influence. And I mean, in that regard, there's no golden standard or rule what you need to review, but basically, if you are aware or you have information that your business partner has a certain relation to a designated person, then you are in any event obliged to further investigate this. And of course, as a matter of pre-auction, in case of doubt, it's better to cease business operations then, which some companies did, but which of course then in turn triggers some questions under civil law, whether this is really allowed to seize a contract under civil law under those circumstances. So yeah, I mean, that's one of the particularities of the EU system, which is from its personal scope narrower than the US system, but which has this particularity of this indirect provision ban. And yeah, so that's and what is also important when it comes to the sanctions related to areas like Crimea and also now Luhansk and Donetsk, to control the end use and to ask your customer if you are, let's say, if the transaction itself to Russia is still allowed, you know, outside from dual use and the new high-tech list, normal exports are not prohibited. But even in that case, it's very important to insist on an end-use declaration that you can prove in case your goods at the end land in the sanctioned areas, that you have done everything to control the end use of those items.
And Vera, just being conscious of time, why don't we move on to Molly, give her just a minute or two on screening, and then David on the end user forms, and then we can sort of go to final thoughts.
Yeah, okay. Molly, can you talk to us about screening?
Yeah, I mean, Michael did touch on it briefly, and I mean, it is rolled up with the beneficial ownership analysis, right? So screening is above and beyond. Everyone should be doing it generally. If there's, you know, if it's a US nexus to any transaction, and then also you have to think about whether there's an EU or Australian nexus, but screening should occur like when you're entering into a transaction, but also immediately before a transaction occurs. So immediately before something's shipped, immediately before you're paying, immediately before you're receiving payment. Because as David mentioned, these sanctions are changing every day, hour by hour. So you need to make sure you're on top of your screening. And right now it seems to be manual, but eventually, hopefully things will calm down and you can rely on, you know, a best practice is to have an electronic screening process where a screening company is integrated with your ERP system and automatically screening shipments you create, payments you create, et cetera. And then I know Michael also touched on what David's going to touch on in the next slide. It's kind of knowing your customer and obtaining certifications from them. So David, if you want to talk about the end user certificates, that would be helpful too.
Yeah, absolutely. And it's something that you can do proactively with your customers. You want to get information on beneficial owners, on the banks that are involved, and all the known end users. You know, you want them to say that, you know, in purchasing this, we're going to comply with applicable laws, and we're not going to put you, the seller, in a position where you will be violative of sanctions by providing something to someone that is sanctioned. The end user will not be a prohibited end user, a prohibited recipient. And not only do you want to get all of your potential distributors with sales into the region, you want to get anything that might reach the hands of prohibited persons wherever they are. Oligarchs tend to be somewhat mobile. No matter how hard you hit them, they still have money somewhere and they still manage to get around a bit. Make sure that it's not going there. One thing to add very quickly, we're talking about all these best practices and do put them into place. Molly said something before very important. It may not eliminate your risk, but it could mitigate the circumstances. At the same time, if you don't do it right, if you have these best practices put in place and you don't actually utilize them, that doesn't look good to a regulator. So here you are, you're asking for end user certificates, and you even, let's say you put in an audit provision saying we can go in and audit and make sure that those end user certificates are being upheld. And then the authorities show up at your place and say, you have a problem. Vladimir Putin's super yacht is completely decorated with your goods. What are you going to do about it? And how has this happened? Oh, wait, you've had end user certificates. That's okay, that's good. But you've got an audit provision too. How can you show us your audit records? Well, actually, I've never audited them. Really? So what good are the end user certificates if you don't know, and all of this good work that you put in up front if you actually don't use it? It can work either way. So know what your tools are and know how to use them so that they actually work in your favor, so that they actually do mitigate that issue, rather than show the fact that you actually haven't used the tools that you have handy, because that's a problem. Again, it complicates matters, but really these best practices or things we're suggesting to put into place so that you can actively use them. It's not, we have a good policy and therefore we're safe. It's, we implement a good policy and therefore we have a response to a regulator.
David, one of my colleagues says there's nothing worse than not having a policy than having a policy that you don't follow. So
Sure.
So that's it for me for end user forms. Where are we now?
Yeah. So now let's go to our audience for some questions. Hannah, I think you received some questions in the chat, right?
I did, and I just wanted to stop my screen share quickly. David, one thing I did want, I don't think you touched on this, but David had a really interesting story yesterday about how it affects you as the individual, right? That you would have, you would not think about this, right, David? So hopefully I'm not calling you out on something you don't want to share, but David has an interesting personal story about how sanctions affected him personally.
And you know, I'm pretty much as far away from all of you as you get on Earth, and pretty far away from Russia and Ukraine at the moment. Last week, I went to pay my children's school fees, the tuition for my kids to go to school. And if you pay it all in one lump sum, you get a discount. So I did that. And my bank stopped the payment because it was an abnormal, out of character charge on my account. And I said, well, that's a good service. I understand that. So I called the bank and gave them all the details, exactly the number to the penny, who the recipient was, why they are getting paid, everything. They took it all down, made notes, put the payment through yesterday morning. They stopped it again because their electronic system for picking up anomalies is set so sensitively that even though they had a full written account of what was going to happen, they stopped the payment again because they're so risk averse that I can't pay my local school. And I had to get on a third time with them. And this morning, happily, the cute little school my kids go to has been paid. But it took a lot of doing. And that shows that not only are the sanctions impacting individuals, but the reaction to the sanctions and the measures that are being put into place have an impact right down to your daily life and have an impact on the way people are doing business. It's changing the way money is moving, it's changing the way services are provided, and it's changing the way goods move from place to place. And it's happening to me sitting in Australia, and which is about as far away from the action as it gets. So it's real. The impacts are at home.
Thanks, David. And there's another question here that I think would be, of interest to our corporate lawyers. From a contractual point of view, and I will throw this out to any of you, maybe Molly, you want to start first. Can sanctions be considered force majeure in events?
I mean, I think it depends on how the force majeure clause is worded, but generally it does say a change in law. And so the way I've seen that interpreted is when there's a change in law that would prohibit a transaction. And I mean, getting a license from OFAC I've had one come back after 5 years. So it's, a change in law that prohibits a transaction without a specific license from OFAC is in my opinion, definitely an argument for a force majeure event. When it's a change in law that just makes transactions difficult, but there's a general license, or you can just use another bank, that's when I would say maybe the force majeure clause doesn't. Conflict areas though, war is a change in law, part of a force majeure clause generally. And so we've seen a lot of insurance companies not be willing to ship into Russia